Law nerds, today was a lot. It is, what day is it here? It's Tuesday, April 16th. I streamed yesterday for the Hannah Gutierrez sentencing, and it has thrown off my whole week. I don't know what day or time it is. Replay crew, everything will be timestamped down below. Today, we are covering a lot of what's going on in the TikTok psychic defamation case. And then I will briefly be covering the lawsuit between Kevin Franke and Jodi Hildebrandt. But most of today is going to be breaking down what is going on in federal court in Idaho. I listened and took notes on the entire little more than an hour hearing. It went much like the previous hearing that I covered in this case. Federal courts are so difficult because there is no streaming, there is no broadcasting, there are no cameras in the courtroom, there's no audio recordings. So we have to go off of reporting. And what I'm finding in this particular case is there just isn't any reporting outside of the internet. So I have made it a point to make sure that I am at virtual is fantastic, that I attend these hearings so I can tell you what happened so we know, because I already see the way this is going to spin. It's like I'm psychic. I can see how this is going to spin. This is going to spin. Well, the TikToker is going to spin it after the court rules. Today's hearing was so much, you guys. Y'all, we had to start at code red. Like, I didn't even change my shirt. I am wearing, yes, it is a 9-inch nail shirt with holes in it. It was my mood when I woke up this morning. And it's still my mood now, but oh my God. You guys. This federal judge, I was telling Judge Abby this morning when we were chatting during her commute to work, I told Judge Abby this morning, I'm like, this federal judge has the patience of a saint. And when I am asked, Emily, would you be a good judge? Would you ever want to be a judge? And I regularly say, in the stylings of Judge Judy, yes. Anything else, no. And here is why I'd be a terrible judge. A, I wouldn't have the patience for any of this. I would lose my ever-loving mind. It's like I am patient for my kids, but I am not always patient for children in general. I try to be, but I'm not always. But I try to be. I would never have the patience for this, and I would lose my mind. And that is not very judge-like. When people interview about me for judicial temperament, I imagine what they would say is, Emily's lovely and entertaining and we enjoy her, but I'm not sure about the judicial temperament part. Her face does much, and that's not going to help. Also, I don't think I could sit through impact statements and not cry anymore. I used to be able to do that. I don't think I could. I have worked on bringing down the walls so that like my emotions aren't just bottled up into like a little teeny tiny box. And once I brought those walls down, I can't put them back up effectively. I just can't. I can't. So no, television, yes. I like doing this. I love doing this. Would I be a great judge? No. Because when this happened, and federal judges are a bit more stuffy than state judges. State judges can be a little bit more colloquial. Federal judges are much more formal. Federal court is much more formal. This was not a super formal hearing because all the defendant in this case wanted to do was fight with the judge, cut him off, and you could hear the tension rising in his voice. You could hear him getting frustrated. No one cuts off federal judges mid-sentence. Well, the TikTok psychic does. So we're going to cover that first. We're going to do a bit of a summary for those of you just coming into this case so we know what we're talking about. We're going to talk about the legal standard, and then we're going to talk about everything that happened at this hearing because if I had to, you had to. If you follow me on Instagram, you know how that goes because now all of you have Toad singing Karma and Chandelier stuck in your head, for which I am sorry, not really, because it's also stuck in my head. It's like when you smell something terrible and you're like, oh my God, this is the worst. Try it. Sometimes we just need to share. Let's get started, you guys. Oh my God.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Okay, the first thing we are going to do to set the stage, and for those of you saying I love the Toad chandelier video, this started with my kid stumbling across somebody who made Take Me Home Country Toad, and the way that my youngest fell in love with that meme. And then we had to play Take Me Home Country Road, which is a song that I love anyway, and I think only slaps at karaoke in maybe Tennessee and surrounding states, because I imagine singing Take Me Home Country Road in like Southern California is not going to play the same, but somehow Take Me Home Country Road is like, I don't know, it just feels right. And I love it. But Take Me Home Country Toad is on another level, and my kid loves it. And so it started with Take Me Home Country Toad. And then from Take Me Home Country Toad, it became Toad Sings Chandelier. And then when Instagram was like, girl, you've had a long day. What you need this evening is Toad Singing Karma by JoJo Siwa, because you can't get onto the internet without that song aggressively and without consent being shoved into your ear holes. Then I was like, I needed Toad Singing Karma to wash out the rest of all of social media singing karma. So it replaced it for me. So it was maybe the palate cleanser that I needed. Damn it, it's still stuck in my head though. But now it's like Toad singing it. It's still stuck in my head. Look, say what you want about JoJo Siwa, but the marketing assault of karma has absolutely gotten it stuck into everyone's head. So even at the beginning when I'm like, I don't know if I like this song, it doesn't matter. It doesn't matter, because there's times I need to listen to it just to scratch the itch, because it's stuck in my head, and my head can do lyrics but not music, because my brain is incredibly unique and connected in all sorts of strange ways. So I need to sometimes hear it just to flush. Anyway, stuck in my head. You can't go on social media, or at least I can't go on social media without hearing it. But the country toad has helped, or the Toad singing it has helped. Bia in the chat said, I only know 3 words from that song. Are they "Karma's a bitch"? Because that's where I'm at. That's where I'm at. And then other things happen. I don't know. That and then other things happen. So this morning I was trying to recenter my soul for this court hearing, listening to Metallica, 9 Inch Nails, Pennywise, The Offspring, and all the other things on my loud mix. That the loud playlist is just like the rock hands is the loud playlist. So I was listening to the loud playlist this morning. I saw somebody saying I'm still stuck on Beyonce. My kid and I were getting out of the first of multiple appointments yesterday morning from the orthodontist office, and somebody was just bumping Beyonce on the street. And I was like, that's delightful. It is. The weather in Middle Tennessee is roll your windows down, like take the doors off the Jeep, take the tops off the cars type of weather right now. And it's been really fun hearing everybody kind of bumping their music. It feels like summer is right around the corner. Okay. Do I have Spotify playlists? No, but I'm contemplating that I need to. So I think we need to. For those of you saying Hozier is my life right now, I get it. Hozier is playing at Pilgrimage here in Middle Tennessee. We need to get to this court hearing, or I'm not going to have time to finish today, because I can't forget that I have a hard stop today. So we need to do a road so far. We're going to do that through the replies in this case. So bear with me. Talking about the TikTok psychic defamation suit, University of Idaho professor is suing TikTok psychic. I am not calling TikTok psychic by their name, because I don't think you should be infamous for being sued. That's where I'm at. The professor sued over statements TikTok psychic made on TikTok and elsewhere. Well, being sued for the TikTok statements. The statements have since been made elsewhere over the University of Idaho murders. The TikTok psychic has alleged that the professor not only commissioned and caused the murders of the 4 University of Idaho students, but she did it because she was having an affair with one of the students. The multiple cease and desists were sent. Those were discussed in the hearing today. The professor then sued in federal court. This has been going on for over 18 months. And George, I was in the middle of a summary, my dude. What's up? George is just like poking his head up at me to get what's going on, bud? Come on. Okay, if you want to come up, come up. If you want to come up, I'm going to give you 3 seconds. All right, you took me up on it. 3 seconds. George says hello, Lonards. I will be covered in hair. It's also that time of year. George is very camera shy. Fred is a ham. George is shy. George, what's going on, bub? You have stuff happening today. I know. You're humans at school. It's very difficult on George that his human has to go to school. George is a gorgeous cat, but right now he is just a very needy fur ball of shedding. And we brushed you this weekend and everything. And the door's open for you to go out on the catio. Oh, he is now banging into my arm like, why are you touching the mouse on your computer and not petting me? All right, I am being aggressively yelled at to pet. Let's get into this reply where I lost my train of thought. Georgie, where was I? Hold on. Wait, go back to me. I was distracted by cat. I'm sorry. So the professor sent multiple cease and desists. Things did not cease nor desist, and then sued in federal court. We'll fix it in post. This lawsuit has been going on for over a year now. The entire thing has been going on for over 18 months. We are now at the motions for summary judgment. All things said, this case has moved pretty quickly. For those of you that are going to inevitably ask, why is this case still going on? The court can't just throw out a case when you sue someone. The court can't just say, I can't believe this is here. The professor has the right to sue for defamation in this case, and that case has to go through process. So if it's just dismissed, and Carrie's like, it should have been dismissed. If it's just dismissed, then the TikToker just gets away with saying whatever they want to say, and the professor has no recourse. So this case has to go through court process if the professor wants some kind of ruling to clear their name. So all of that, we're going to go through a bit of a summary with the reply from the professor. Also, my empathy is tired after today's court hearing. I'll get to that. Emily, just hold on. We'll get there. We're going to do this quickly. Plaintiff's reply in support of plaintiff's amended motion for partial summary judgment. The motion for summary judgment is asking the court to find the TikToker liable. And after the TikToker is found liable, it goes to trial on actual damages. That's what they are asking for in this filing. TikToker says defendant TikToker has put, or plaintiff professor says, defendant TikToker has put forth zero evidence to rebut the facts set forth in plaintiff's amended motion for partial summary judgment. TikToker sets forth no facts contesting that she published statements that Professor Schofield murdered 4 University of Idaho students and that Professor Schofield was having an affair with one of them. In fact, she makes similar and even more inflammatory assertions about the professor. True. These statements are defamation per se. TikToker puts forth no facts that give rise to any inference that her statements are true. They are not. The professor's undisputed declaration is sufficient to prove the falsity of TikToker's statements. Summary judgment as to liability is appropriate. This is what I need you to keep in mind. This next part. This is important. This part's important. The moving party for summary judgment bears the initial burden of showing the absence of any genuine issue of material fact. This is the first prong of the legal standard. If you are making an outline, it's 2 prongs. Professor Schofield, they are arguing, has met this burden. It then shifts. The second prong then shifts. If the court finds that Professor Schofield met the burden of showing an absence of any genuine issue of material fact, then the burden at this motion stage shifts to the defendant TikToker to prove that there is a material issue of fact. Professor Schofield set out facts showing Gouliard published the statements on TikTok, repeatedly claims the professor orchestrated the murder of 4 students. Oh, the TikToker called the professor a murderer in the hearing today on more than one occasion, and that the professor had an affair with one of the victims. The professor sets forth facts that are sufficient to prove the statements were defamation per se. Remember, defamation per se means you don't have to prove damages at the outset, that the things being said are themselves defamatory. So with defamation per se, we went over the standard in Idaho. It includes accusing someone of a crime that's a felony. Murder counts. No one's disputing it. And also impugning someone's profession. And we went through all the legal standard on that motions ago. But saying you're having an affair with a student would impugn your profession as a university professor. And they proved that all of the university guidelines show that that is not within the standards for the University of Idaho. So it impugns the profession. They say that the TikToker's statements unambiguously imputed to Professor Schofield conduct constituting a criminal offense, punishable by imprisonment. And they also unambiguously ascribed to her conduct characteristics or a condition that would adversely affect fitness for proper conduct of her lawful business, trade, or profession. That's the second part. I'm glad they restated it. Emily, you should have kept reading. Once the moving party has satisfied its burden, the non-moving party, TikToker, must go beyond the pleadings and designate by evidence, affidavits, depositions, answers to interrogatories, or admissions on file, quote, showing specific facts that there is a genuine issue for trial. An issue of fact is genuine if there is sufficient evidence for a reasonable fact finder to find the non-moving party or find for the non-moving party. A fact is material if it may affect the outcome of the case. And it needs to have like evidentiary support. Monster 0711, yes, the hearing happened this morning. And I am going to break it down for you after we do this. Those hearings are not televised streams or otherwise. They are accessible to the public, but they are not recorded or replayable. So I'm going to relay and report on what happened. Hi, Georgie. He keeps headbutting me. Like, why did you stop petting? If you sat the other way, then you would have my free hand, not the mouse hand, cat. He's like, no, that would be too easy. A party opposed to summary judgment must establish a dispute of material facts using actual evidence. The opponent must do more than simply show that there is some metaphysical doubt as to material facts. That's from case law. Okay, go on, go see the birds. The opposing party or the party opposing the motion may not rest upon mere allegations or denials of the pleading, but must set forth specific facts showing that there is a genuine issue for trial. So this is where we're at going into this hearing. Crystal Wynn asked Emily, are you going to give us a play-by-play of the hearing? Yep, that's what we're doing. That's what we're doing next. One crazy cat said, I love that metaphysical doubt is in case law. Oh yeah. Gouliard has not met her burden. Oh, cat glitter. It is undisputed that Gouliard has accused the professor repeatedly in multiple forms of a quadruple homicide and having an affair. The burden shifts to Gouliard. In her opposition, Gouliard was required to go beyond the pleadings and designate by affidavits, depositions, answers to interrogatories, or admission on files, quote, specific facts showing that there is a genuine issue for trial. Instead, Ms. Gouliard simply set forth an unsupported narrative, falsely alleging in even more inflammatory detail that the professor has been having an affair with one of the murdered students and hired another student to kill her and the others to cover it up. Indeed, Gouliard added even more unsupported facts alleging activity by the person hired to commit the murders. Her new narrative is not supported by any affidavits, depositions, answers to interrogatories, or admissions. It is simply a fantastical story based on a series of false statements by TikToker. TikToker brings forth no facts that show that she did not make the defamatory statements. No, she admits to making them. Nor does she even argue that they are not defamatory. She argues instead that her defamatory statements are true because she received them in a tarot card reading and believes that they are true. That's exactly what she's arguing. That's exactly what she's arguing. And then she started arguing that she's the flesh of God, but we're going to get there. While truth is a defense to defamation, TikToker has zero facts to show her statements are true. Simply believing something is true does not make it so, particularly in the face of actual facts to the contrary. Gouliard's assertion in the opposition are unsupported by any evidence. We're going to summarize that as evidence. TikToker attaches 8 exhibits to her opposition. Even if the court could properly consider any of them, not a single one establishes a genuine issue of material fact. Not a single part of any of them establishes a fact showing either that the professor was involved or that she had an affair with one of the students. Indeed, the only exhibit that bears any relationship to who committed the murders is Exhibit E, the probable cause affidavit that established the basis for arresting Brian Kohberger. But not one word of the affidavit suggests in any way that the professor was involved. To the contrary, it only shows that there is probable cause that Brian Kohberger alone committed the murders. Gouliard, TikToker, argues that the professor has the burden to prove falsity. That is incorrect. This is a restrained pleading. This is a fundamental misunderstanding. And after hearing this hearing, I believe a fundamental willful misunderstanding, because they went round and round and round and round on this. Under Idaho law, truth is an affirmative defense to defamation. Gouliard has the burden to prove, not the professor. Even if the professor had the burden to prove falsity, she has done so here. This reiterates a lot of what she said in the hearing. The court should grant the partial summary judgment. The other motion that the court needs to consider is a motion to amend the complaint for punitive damages. The professor is saying the court has to allow punitive damages to be added because it is the only way to stop this fuckery. I'm summarizing. Reply in support of the motion for leave to amend complaint to add punitive damages. Defendant TikToker has no facts to support her extreme and outrageous assertions that the plaintiff had an affair with a student or planned, etc., the murder of 4 university students. In the face of overwhelming evidence to the contrary, TikToker has continued to participate in YouTube videos repeating these false statements. Indeed, she participated in a YouTube video repeating her false statements at least once more on February 8th, 2024. Since the professor filed her motion, CEG YouTube video. I'm not giving anything views in this case. TikToker opposes professor's motion for leave to amend her complaint and add punitive damages by ignoring her own ongoing conduct and by using the wrong legal standard. TikToker is undeterred by the facts and her own failure to produce a single shred of evidence supporting her claims. Yes, she is basically the ringleader of a clout circus at this point. Clout circus, by the way, came from one of the first filings in this case. Punitive damages are necessary to deter her. This court should grant the motion and allow her to file a complaint to add punitive damages. Remember, if this goes to trial, it seems that it will only go to trial on damages. I think the plaintiff has a very strong case here that the summary judgment will be granted. And I think the court went a long way today to make a record to grant that summary judgment. Argument. To amend a complaint to seek punitive damages, a party must show a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. And then they go through the TikToker's outrageous conduct to argue that punitive damages should be awarded. And this is why punitive damages would be awarded. This is the standard. A reasonable likelihood that they could prove by a preponderance of the evidence that the defendant acted oppressively, fraudulently, wantonly, maliciously, or outrageously. Moreover, since the plaintiff need only show a reasonable likelihood of establishing its entitlement to punitive damages, the court reviews the evidence in the light most favorable to plaintiff. TikToker did say today that it was her right under the law to ignore the cease and desist, which is one of the few things I agreed to, but what she said surrounding that was interesting. To provide some support for her assertion that she did not act wantonly or maliciously, and she was simply trying to help law enforcement in Idaho solve the murders, TikToker attaches to her opposition a December 10th email that represents she sent to the FBI tip line the same false story upon which the professor sues for defamation. She argues the email shows that she was making a noble effort. She said that multiple times today, that this was a noble undertaking, that she was making a noble effort to assist law enforcement. Notably, the email that TikToker argues was her quote unquote noble effort was sent well after TikToker published multiple TikTok videos falsely stating that the professor had orchestrated a quadruple homicide to cover up an affair, and well after TikToker received 2 cease and desist letters. Rather than demonstrating any effort to assist law enforcement by providing a legitimate tip, the email supports the motion for leave to amend to include damages. It shows that despite being informed on multiple occasions her statements were false, she persisted in making them. The email corroborates other evidence showing she committed a bad act and had sufficient bad state of mind. The TikToker takes tremendous issue with being told she has a bad state of mind. She says that she is noble and that she is seeking justice. The email shows that TikToker continued to make statements that were false without any understanding of or disregard for the likelihood of their consequences. As the professor pointed out, TikToker has made even more false statements since the complaint was filed, has attempted to capitalize on the notoriety of her false claims by appearing on YouTube videos repeating the false statements, asserting that there is evidence to back them up. Now is the time for evidence, and guess what? We're going to have to go to the FRE, but so far, evidence seems in short supply for the TikToker. Then failing to ever seek discovery or produce such evidence. This is because no such evidence exists. Moreover, the false statements on YouTube, all of which occurred well after the email tip to the FBI, also came well after Moscow PD issued a statement that the professor was not involved. TikToker takes issue with that too, by the way. We'll get there. The timing strongly demonstrates TikToker's bad state of mind. That's a quote from case law. It shows that the ongoing false statements were made with malice, oppression, fraud, and gross negligence. Finally, allowing the amendment serves the primary purpose of punitive damage. It may be the only thing that will deter the TikToker from continuing to make these false statements. Nothing else to date has even remotely prompted TikToker to correct her behavior. Accurate. Nothing has indicated to TikToker that she needs to correct her behavior. So let's go to the motion hearing. The court started out. Let me swoop. I'm going to summarize the hearing for you. I spent over an hour typing furiously. The court started out reminding everyone that they could not broadcast, record. I don't think they said broadcast, record in any way, distribute in any way the hearing. There were 14, 15 people from the public on this hearing listening in, but the court reminded everyone again that this hearing cannot be reproduced in any way. If there is, or you ever see audio of the hearing, that is in violation of the federal rules. So the court starts out with what the motions are and how arguments should go. The court sets a very tight parameter for this hearing and what is appropriate and not appropriate. The court states that he's giving everyone 20 minutes to argue, and that he's going to try to keep it within those bounds. Again, I don't know if this is this judge's practice or if because TikToker is representing themselves pro se, that the court is trying to keep it reined in. It didn't work. And this hearing went like the other one. The court tried to let the TikToker make their arguments, and then that didn't work, and the court took over. The plaintiff's argument started out with a disagreement about the standard, and the court asked about the standard, saying there are disagreements over the elements of defamation here. And the TikToker has pointed out these elements, these additional elements, and the additional elements have some basis in case law. So the court asked the plaintiff to address that. And the plaintiff addressed it right off the bat, saying, yes, there are these additional elements, malice being one of them. Yes, there are these additional elements, but that is for a public figure. And there is no argument and no disagreement to the fact that the professor is not a public figure. So the court asked the plaintiff to directly address the defendant's argument that there is no malice has been proven, and they did address it head on, saying the jury instructions with the two additional elements are for public figures. We're not dealing with a public figure here. And you don't have to prove that the statement is false and that the defendant reasonably should have known the statement was false. So the three elements they are dealing with are the elements that they have been, the plaintiff argues, lining out throughout their pleadings, because those are the elements for non-public figure defamation per se. And so the plaintiff wrapped it back around to, no, we don't have to prove malice. This is not a public figure. And we don't have to prove damages. This is defamation per se. We only prove damages to get damages. So you only have to prove damages when you get to the money part of the trial. You don't have to prove it as part of the pleading as a tangible number. Reputational damage is accepted by the law when the things that are said. It's accepted that if you say someone is a murderer, that's reputationally damaging. Accusing someone of a crime is reputationally damaging. Different states have different things for defamation per se. I saw a question that I wanted to talk about. Wannabe Trucker 74 said the professor is a public figure now. The professor is known now, but you can't drag someone into a controversy and then make them a public figure so that they can't sue you easily for defamation per se. So even though the professor is now known because of this, that's part of the damage, not evidence. And I don't think you were saying it was. I just wanted to remember to say it, but it's not evidence that the professor was a public figure when these things were said. And it's different than if you're talking about a politician. It's different than if you're talking about a celebrity. It's different when you're talking about somebody who has inserted themselves into public life versus a professor who was doing their job and then dragged into a controversy by the things that this TikToker was saying. So even though she is now known because of this, she was not a public figure when the statements were made. Therefore, the defamation standard should not be public figure defamation. And nobody's argued that it should be, because the TikToker never said that. Even though she's tried to get to that, she's never gotten to that in any of her filings because she's never said it in any of her filings. Hopefully that makes sense. Wannabe Trucker was like, got it, great. I love it when you guys ask questions because then it helps me remember what to break down. So thank you. We learn through questions. That's why I always say I have questions. We learn through questions. The plaintiff goes on to say that the elements for defamation for a public figure, again, doesn't apply here. She's not a public figure. That the defendant can't make her a public figure by dragging her into the controversy. That the TikToks aren't in controversy. The defendant doesn't deny that they're her, doesn't deny that she posted them to TikTok. There's no denials here. Hannah said, Emily, did you go to the hearing? Yes, I did. Not in Idaho. I went by phone. But yes. They go on to say and talk about the unequivocal admissions in the request for admission. This was all in the first motion for this motion for summary judgment. We covered all the requests for admission. The TikToker admitted quite a lot. That's the basis here. The TikToker admits that she posted the TikToks, admits that she said what she said. Her argument is not, I didn't say it. Her argument is it's true and you didn't prove it's not true, murderer. That's her argument. The court interrupted counsel and said, I'm sorry to interrupt, but I've reviewed all the TikToks and the requests for admissions if it helps. Like, I'm fully aware. Unless you need to point to something specific, I'm well aware. Georgie, you were up and now you're down. You just want to be everywhere. You can go a different way. You can go that way. The plaintiff then argues that defendant in the request for admissions says in a lot of the admissions, but discovery will prove XYZ. The plaintiff points out again for the court that December 15th, 2023 was the discovery deadline. Discovery is closed in this case. There is no further opportunity for discovery in this case. It is fini, done. Like, niet, no more discovery. No more discovery. Done. So the plaintiff again points out that the TikToker has no further time to put forth evidence, that now is the time. So the TikToker had to put in their response, depositions, affidavits. Look, when I worked for two different judges in the Superior Court as a research attorney, when we dealt with motions for summary judgment, there were times they were bankers' boxes of evidence, because it is determining material issues of fact without a trial. And the judge and the research attorney, in this case, the research attorney is like, this is me guessing. Come on, George, what are we doing? You're doing things on cat time. We're streaming. He's just staring at me like, why? Come on then. You have 3 seconds. Thank you. Counting to 3 works really well with you. All right. The research attorney didn't have much to do because there aren't boxes and boxes and boxes of stuff. Normally in summary judgments, you have all of the depositions, all of the everything, because everything is already done. All of the discovery is done. So in this case, the TikToker has done no discovery, and the court asks her about it repeatedly. We'll get there. So there's no boxes of deposition transcripts there. And summary judgment can be really helpful to determine material issues in a case, or where there's no question as to fact. This happens in complex civil litigation quite a lot, where it's like, okay, these facts are not in dispute. We've narrowed it down to what's in dispute only. And narrowing it down to what's in dispute only can help trials move quicker. The jury is the finder of fact. Why ask them to find a fact that's not in dispute? So this summary judgment is trying to tailor down if there are any material issues of fact. Again, the plaintiff, if they meet their burden, the burden shifts to the defense to prove that there are material issues of fact that must be resolved by a jury. The plaintiff goes on and says that not a single shred of evidence disproves that this is defamatory. No discovery, nothing has come forward in the criminal case that proves that the professor was involved, and said the TikToker, she called her by her last name, but says she knows that the TikToker knows there's no evidence to support anything that she has said. There's no evidentiary support of it. Even if the standard was to prove reckless disregard for the truth, that standard's met. So even if this was a public figure case, we could meet that standard too, Your Honor. We don't have to, but we could. They go on to say that there's no facts put forward by defendant, no evidence that supports the fantastical theory, and they called it fantastical a million times, which I know the TikToker took issue with based on her statements later and based on her statements at the previous court hearing. She feels very maligned when people call these fantastical theories. Fantastical is a kind way to put it. They then argue that the TikToker has not put any issue of triable fact forward, and that no reasonable fact finder could find anything other than liability for TikToker at this point, and that's the standard. Then she moved on to the amended complaint and says, it's always been the plaintiff's goal to make the defendant stop making the false statements, and it seems that punitive damages are the only way. She goes through the arguments that she made and then says, even with the multiple cease and desists, even with the initiation of a federal lawsuit, even with all of that, the TikToker has continued to repeat her, quote, fantastical allegations. Okay, there's a desk here. Do you want to? Okay. And a microphone, Cat. The court interrupted and said, okay, you said 4 times the defendant has made more statements. What are those additional statements that would be helpful? Which indicates to me that the court would like the plaintiff to point him to where does it show the ongoing statements after the lawsuit so that I can consider that for the punitive damages. And then the plaintiff cites the court to where the additional statements were made, interviews on YouTube, additional TikToks, etc. They said the point of punitive damages is to deter. It's true, they're punishment damages. And that the plaintiff needs to be able to deter the defendant from persisting. I know that this plaintiff, I speculate strongly that this plaintiff is very concerned that the plaintiff will win this case and the TikToker will continue to make these allegations and they'll have to do this all over again. Like, what will stop the TikToker other than maybe a court-ordered, like we saw in the Cardi B case? Like in the Cardi B case, after the jury verdict against Tasha K, they went through that and said, okay, there needs to be a full court order saying these are the things you cannot say. And I think that's going to happen here to do a full court order and punitive damages to stop her. But I don't know if monetary damages will stop her. I don't know if there's anything other than an injunction that carries the potential of contempt of court. I think that's all that is going to stop this is the potential for contempt of court and for there to be potential penal consequences. I don't know if money is going to help deter her, but an injunction may. Smurfana was just reminding the chat that she won't get incarceration unless it's contempt. And I think that might be the only thing the court can do when we get down the road here. And I saw some of you asking for a screen share. These are my notes and they are disgusting. And so I cannot screen share because I am embarrassed because my notes are disgusting. And they are covered in red lines being like, you spelled all these things wrong because I was typing quickly. So they are just my notes. There is nothing, I am reading off of my notes. They go on to say that the TikToks themselves are evidence and there's no facts supporting the fantastical allegations. They say that the TikToker, no, they're messy, they're sloppy, they're misspelled, they are not cute. Question, could they garnish any revenue earned from TikTok social media platforms? She's been yeeted off of TikTok. I don't know if she has an employer, but they can try. But the amount of money it takes to go after enforcement can be very difficult. You're now sliding off my lap. Okay, George, you are a menace to streaming today. You were doing all the things. Oh, streaming with cats. So the plaintiff argued that the TikToker said clearly in her counterclaims that everything she said was based solely on her ability to psychically divine the truth. That's a direct quote. And it's clear that the allegations are baseless and without any factual or evidentiary support. They reiterated the goal is to get the defendant to stop. There have never been facts that support the fantastical claims, and for over 18 months, the plaintiff has simply been trying to get the defendant to stop. And punitive damages may be the only thing, so they're asking for leave to amend to add the punitive damages. And the court then turns to the defendant and says, it is your turn to argue. What the court is expecting here is that the TikToker will argue why, if the burden shifts to her, there is like evidentiary support and facts to support her claims. I do see that it is, Kat Ashley did say, I have cat glitter, that it is my job to let George do whatever he wants. I mean, he believes that too. Will punitive damages stop you from defaming George? There is no defamation here. Justice for George. George is a menace. George, you're a menace. He's now watching the cats. The cats weren't entertaining enough earlier. So the court turns to TikToker. And TikToker opens with, since the beginning, I shit you not. This is why I was typing so fast and my notes are horrible. Since the beginning, the plaintiff has perjurously misled the court and the public that I have to argue for respect and plausibility to practice my spirituality. And then she begins quoting the Bible. The TikToker was there via Zoom. Everybody was there via Zoom except the public who were there via phone. She then quotes very quickly multiple quotes from the Bible and read them very fast, so I didn't get them except for the last one, which said that the Spirit of God lives within human flesh and that she has started, or she has worked the last, I think she said 5 years, I could be wrong on the years, to align her spirit and her flesh so that she can receive messages from God. And that is what she has done. Remember, her email is ashisgod. I will tell you, the TikToker is not, I can't say she's not believing what she's saying, but I don't know if she believes all of it. She is not unintelligent. She plays word games with this court, which makes it very clear that she is aware of what's going on and plays word games with him the entire time. She is not unaware of what is going on. She might not perceive the severity of what's going on, but she is not unaware of what is going on. And she willfully attempts to spin what the court has said. And she is not, in some areas, she is trying to lean on her understanding of her religious freedom and the First Amendment. But she is very willful in not hearing the court when the court points out that that's not at play here. And very, very willful in refusing to actually hear what the court has said to her. But she believes that God lives in human flesh and that she has aligned her flesh and spirit. She said flesh like 6 times. I was like, why does that word bother? Ugh. Like, I don't know. I can't. My son hates the word facial. I apparently don't like the word flesh. I didn't even know until today. It's like, stop saying flesh. It's weird. There was a game that my kids used to play that involved flesh. It was not Minecraft. It was one of the Terraria. There was Terraria. There, flesh was involved. Anyway, flesh. So she said that she had, so many times, she had aligned her spirit and her flesh so that she can get a message of what is occurring in the past, present, and future because her flesh is aligned. And she is not only omniscient, but also omnipotent because God lives in human flesh. I wish I was exaggerating in any way. I am not exaggerating in any way. She told the federal court that she is omniscient and omnipotent, among other things, and used quite a long list of words that she has used in all of her pleadings. I could not type that fast. She also said that she has used her tarot cards to accurately predict the death of a soldier. I hate that that individual's family is being dragged into this and their story is being shared in this. I covered it in one of the filings. It was a soldier who was very much struggling with mental health. It seems that she was called to do a tarot reading about the state of his mental health and predicted he would take his own life. And then quite some time later, he in fact did. Mental health in this country is a tangent I don't have time to go on today, but to say that more and better is needed. We'll stop there. She then gets back to talking about her clairvoyant ability. Sometimes she is called a medium. And that she uses her clairvoyant ability to share her findings on social media. I now made a note to myself that said, oh, she's very clearly avoiding the point. She said she uses her gifts for something better than relationship readings, and the way that she had a disdain. Like there was a very strong, for me, and this is just me listening to what she's saying, a very strong disgust, disdain, and judgment of relationship readings. She sees herself as doing something much more significant and important. She also said that she works to get justice for people who ask for answers. And that a TikTok user asked her to get answers for the 4 university students that were found dead. And so she uses her gifts to do that. And that is noble, that she is seeking justice. And it's not, the vibe was, it's not defamation, Your Honor. I was answering a question. I didn't start this. I was answering a question. So she then goes through how she intuitively investigated this case, which she has put in every single one of her filings that I am not going to go through. So she said she asked the cards the who, what, where, how, why of the university students that were murdered. And the intuitive message was that a teacher was involved and that she enlisted the help of 2 males. And then she conducted psychic readings on the entire history department. She started sounding very emotional, and I couldn't tell if she was nervous, but her voice was kind of cracking. And I couldn't tell if that was nerves or I couldn't tell it because I couldn't see her face. But through this part, she was very emotional, but it could have been nerves. She said that most of the history department was in disbelief and afraid, but then when she got to Professor Schofield, her psychic reading led her to the fact that the professor had an affair and commissioned the murder. And she said the only reason I got involved, the only reason I put my neck on the line was because I did a reading about law enforcement, and it revealed that the co-conspirators of this murder would not be brought to justice without me. So she believes that law enforcement will never get it right without her involvement. So she decided to send her findings to the FBI tip line and share them on social media. As the plaintiff pointed out, that timing is wrong. That timeline doesn't line up. So the court cuts her off at this point and starts to redirect her to the TikToks. And the court says, I appreciate the background. The court was very patient at this part. I appreciate the background. You've said this in your pleadings, but we need to get to the TikToks and the statements in the TikToks. And the court asked multiple times, and we're going to go back and forth and back and forth. Do you agree, or the plaintiff is alleging that the TikToks are defamation per se. You're alleging she committed a crime. They're alleging that they are defamatory per se. Would you agree that if your statements were untrue, that they are defamation per se under the standard of law? And she said, I disagree. I absolutely. And she kept talking, and the court's like, wait, why? And she said, because I don't have the intent. Defamation implies that you did it with an intent to cause harm and knowledge that it's false. And I didn't intend to cause harm, and I don't believe that it's false. The court interrupted and said, I'm not getting into that. Defamation per se, the allegations that are untrue, are defamation per se because of the types of allegations made. Do you agree that if they are untrue, that they are categorized as defamation per se? And she said, I disagree because the intent has to be there and there's no intent there. And the court said, no, I'm asking you about questions of truth or falsity. Is it fair to say that your evidence that underlies the TikTok comments is based solely on your tarot card readings and psychic intuition? And then the court continued to say TikTok and psychic intuition more than I ever think a federal court maybe ever has. And we get into probably 30 minutes of this, and I'm going to go as fast as I can. Because the court at this point is like, that's not what I'm asking. And I think the court is trying to circle her around to answer and does it like 2 or 3 times to make a record, and then realizes that she's not going to answer and moves on and is going to have to make his ruling on the pleadings. Based on everything the court has said today and the questions asked, I think this motion is likely to get granted. I don't know about punitive damages. I think it should. I don't know what the court will do. The court has been very restrained. Very restrained. But we're not going to, I don't know if the court is going to get there, and I don't know if it will help. Dan asked, why is Kohberger in the thumbnail? Because all of this is about Kohberger. Because without the Kohberger case, we're not in this defamation case. And it came up in the Kohberger court in the last court hearing. The TikTok defamation case surrounding the University of Idaho murders came up in court last week. So that is why Kohberger is there, because it is about this case is inextricably connected to that case. So the heading and the title should make it very clear. The court said, again, as to questions of truth or falsity, is it fair to say your evidence that underlies the TikTok comments is based solely on your tarot cards and psychic intuition? And she said, no, it's aligned with the university's history website and the Kohberger investigation. My note here is she's being incredibly evasive. She said, I also use light investigative techniques. And I can't tell if she means light, L-I-G-H-T, as opposed to like shadow, or if she means like L-I-T-E, like they're just not heavy. So it was hard for me to tell. I think she is using light as opposed to shadow versus casual or not as heavy. So the court never asked her to define exactly what light investigative techniques are. So whether it means light work as opposed to shadow work or in depth as opposed to superficial, no idea. Could be. Does it really matter? No. The court then interrupts her and says, but did that produce any documentary or testimonial evidence? And she says, no, I don't have to, and I don't have the power to. Remember, when you're a party, you have the power to use the subpoena power of the court. The court says, have you pointed to any documents, affidavits, admissions by plaintiff, or deposition to support your TikTok comments about her? And after round and round and round and round, she said no. And the court said, did you make requests for admissions? And she said, no, I didn't think it would be productive. She's just going to deny it. Ma'am, court operates on a finite set of rules. It's what I really like about court. And maybe that's because I am so neurodivergent that having a formal set of rules makes me feel more comfortable. I think it's why I was so sideways when one of the attorneys in the Gwyneth Paltrow case was chewing gum. I'm like, there's rules. But rules sometimes for the neurodivergent brain can not only be very comforting, but then I don't want rules applied to my life. Like, ooh, don't tell me what to do. Like, I don't need a bedtime. You know what I mean? But the societal rules of when we go into court, we're all going to do this the same way is so comforting. Like, hey, there's a structure to this. I don't have to do the things I don't do well, executive function. I don't have to try to read between the lines on anything. There are rules. And the rules of evidence. Wait, this is the rules of procedure. Damn it, Emily, where are your rules of evidence? Hold on. The rules of evidence are finite. I wouldn't say they're simple. They're finite. I need all of my rules. Give me my rules. I need all of my rules. But we have to follow the rules. Like, the rules for evidence are the rules for evidence. If it's not the rules for evidence, not evidence. So, I saw the comment, rules are not the laws. Rules are how we explore cases. Is this defamation? Is it not defamation? Is this evidence that can come into court? Well, the law is the defamation. How we determine if something is defamation or not is through the rules. It's like that scene, Big Hero 6, where he has a very organized workbench, and somebody takes one of the tools, and he's like, society has rules, people. I'm like, yes, I feel seen. Where are our rules? Our rules of evidence. We have rules. You have to follow them. Rules. So when she is saying, I didn't make any requests for admission because I didn't think it's productive, she just threw out any ability for her to gain evidence, which is what is going to be the end of this case. Because I do think this motion will get granted. I will be very surprised if it doesn't. The court then reiterated, but you understand that the discovery period is closed. There is no further opportunity for you to request admissions, for you to do depositions. There's not been a single deposition in this case. For you to make subpoenas, for you to do any of the other things. So you understand that the time has passed for you to gather evidence. And she said, yes, I understand that. The court at this point just took over questioning her because she wasn't answering any of the record that he needs to make, especially seeing that the court is probably going to grant this motion and end this case short of damages. So the court needed a thorough record. The court did that by questioning. And the court said, I understand that you are representing yourself. The court said, your answers indicate ongoing discovery. Did you request anything? She said, I made those statements in December 2023, and I was focusing on those responses, not completing discovery. And the court said, I understand that you're representing yourself and that you're not a lawyer, but you didn't ask for an extension for discovery. You didn't do anything. Do you understand that you have no further opportunity to get discovery in this case? And she said, yes. The court said, going back to the tarot cards and your clairvoyance and your light research. I'm saving questions as I see them go by. In order for you, and this is me typing directly what the court is saying, if the burden shifts back to you to show a genuine issue of material fact that has to be supported by admissible evidence, as I look at your tarot, the clairvoyance, etc., I don't think the court said etc. I think he listed more things than I said etc. because I couldn't type that fast. The only way it's admissible is by lay witness opinion, and then he defines what a lay witness opinion is. We're going to go to the rule in a minute. But for it to not be hearsay, it would have to be a lay witness opinion. And he says, but the legal requirement is that the testimony is rationally based, and this, she did not like this. Rationally based, and the court said rationally with emphasis. Rationally based on the witness's perception, first person perception, and helps support the jury's conclusion. he continues to define rationally based and uses case law to cite rationally based. Firsthand observation that is supported by verifiable fact. Firsthand observation, not a spiritual witness, firsthand observation that is supported by verifiable fact. And so I know you're saying, but Emily, the rules of evidence are quite small. Yes, but this is only one of the books that starts to interpret them. They seem simple on the surface. This is the tip of the iceberg. The case law is the rest of it. The court then cites Rule 701, rationally based on perception, and she starts arguing, cuts the judge off, and starts arguing, but it's based on my tarot cards. It's rational for me to believe what my tarot cards say because I'm a spiritual intuitive. So it is rationally based for me. This is now getting into a my truth argument. And look, I need my truth and my truth is rationally based is not going to fly in the rules of evidence unless it's also supported by verifiable fact. And she says it's rational for her to believe it. And the court says, but it needs to be objectively verifiable. We're going to read Rule 701 in a minute. And she says, and this is where I'm like, you are just playing word games with this court. She says, but it could be verifiable in the future. So it is objectively verifiable. It just hasn't happened yet. So she starts arguing it just hasn't happened in this timeline yet, essentially. And it is objectively verifiable in the future. It just hasn't happened yet. So it's not objectively verifiable now, but it can be in the future. And then she just starts arguing about the word verifiable. For those of you in the chat saying this can't be real, it is being real. And yes, Bex, I do think she was being intentionally obtuse with the court. There were lots of word games happening with the court in a way that proves that she knows exactly what she's arguing. Like, this is not someone who is unintelligent or unable to perceive what is happening. She is very tuned into what the court is saying and arguing her perceived nuances of words and trying to fit them into her perception of reality, which is not objectively verifiable. But she is definitely living within her perception and everyone else is wrong. So Rule 701. Where are we? 704. Wait. 701. And you know the court spent way too much time, because how do you argue with someone who says, but I believe it? Now what? Trying to argue against a non-attorney can be very difficult. And it harkens back to Clueless, like, I can't do my assignment if she didn't do hers. You can see how I could hear how hard the court was trying to bring rational, linear argument to this conversation of, but I can access the past, present, and future because I am omnipresent, because God lives in the flesh of a human and I have aligned my flesh with God, and that's why I receive messages. How do you have a linear conversation about the rules of evidence with the person who's like, but it is rational to me? It's like, but that's not how this works. So 701, opinion testimony of a lay witness. If a witness is not testifying as an expert, testimony in the form of opinion is limited to one that is rationally based on the witness's perception, helpful to clearly understanding the witness's testimony or to determining a fact at issue, and not based on scientific, technical, or other specialized knowledge within the scope of Rule 702 experts. So the case law goes on to interpret this as something that is supported by verifiable fact. Otherwise, it's hearsay. The court then starts to get annoyed because she keeps cutting him off and jumping in and talking over him. And when the court tries to redirect the question, she continues to just talk over him. And you can hear it. Like I can feel the simmering of like, I am a federal judge. No one interrupts me in my courtroom. And that is true. They do not. So he starts getting annoyed and he says very clearly, I know of no case law, and this is a direct quote, I know of no case law and no court that holds tarot cards and spiritual intuition to be rationally based and admitted under Rule 701, and you have not presented any such case law. And she cuts him off and says, law enforcement uses clairvoyance. And I attached the FBI's list about using clairvoyance and then keeps talking over him. And the court says, that's not what I asked. That's different. And then she cuts him off again. And the court says, you're going to need to let me finish. And says, there may be valid uses in other context, but your burden here in defending this motion is that you have to establish a genuine dispute of verifiable fact based on admissible evidence. And I know of no case where a lay witness can give an opinion based on tarot or spiritual intuition. And then she cut him off again and started arguing that it's not her burden. And the court said, no, I need you to answer my question. And you need to understand that at this stage, to defend this motion, you have to come forth with specific evidence that raises a genuine dispute of material fact with admissible evidence. And I have found no such ability except under Rule 701, and tarot and spiritual intuition aren't admissible. So you need to support this with admissible evidence. So the court says, I need you to tell me, what are these specific facts, evidence, documents, statements that are admissible evidence that bears your burden in court today? Remember, once the plaintiff says there's no fact in dispute, it shifts to the defendant to show that there is a fact in dispute. The court is going to have a very long opinion when they write it. And she says, this is the problem. The plaintiff is trying to get this court to shift the requirement on me. This is not my requirement. This is not my burden, and this is not my responsibility. The Supreme Court says that I don't bear this burden under the First Amendment because the only thing they presented was a declaration, and I don't have to present anything because I have the right of free speech. And my right of free speech means that what I say is supported by the Supreme Court. And she starts telling the judge, maybe you don't agree with the Supreme Court, and throwing it back on him. Like, she is fighting with the judge at this point that the judge doesn't understand. And the court said, next, if I decide that the plaintiff has met their burden based on what they put forward and all the exhibits that they have put forward, they bear the burden that there is no genuine dispute, then it shifts to you to establish there is a genuine issue of specific fact based on evidence that's admissible at trial. And she cuts him off at the end of that statement and says, it's not a requirement of me. I don't have to have evidence. That's not what's required of me. And the court says, I'm telling you that that's what's required of you. And I'm telling you that you have to present evidence, because if the burden is shifted back to you, and then she cuts him off and says, no, the material fact in dispute is that I have noble intent, and they're saying I have ill intent. And I feel that I have proved evidence of my intent. I don't have ill intent. The ill intent goes to the punitive damages. It doesn't go to this motion for summary judgment. So, for anyone asking why we started at Code Red today, I hope that we're feeling our Code Red vibes. For those of you asking why isn't she in custody, this is a civil case. She is the defendant. She has been sued. And she's like, that is a material dispute. I have noble intent. And I feel that I have proved evidence of my intent. And the court, my note is the court is losing patience even more. The court says, what is your evidence? Focusing on evidence that is admissible in court. I'm going to have to order the transcript for this. That the plaintiff was involved in the murders or the affair. What is your evidence? And she says, Your Honor, if you're asking me for evidence of a crime, that doesn't make any sense to me. I don't have evidence of that. And I don't have legal authority to get evidence. You're asking me to investigate a crime. That line right there, when the court pulls the transcript, quote, I don't have evidence of that and I don't have legal authority to get evidence. Ma'am, you could subpoena whatever the fuck you want. You could ask for admissions or denials. You had quite a lot of power. You should have asked your lawyer. Ma'am, ask your attorney about the subpoena power of the court that you as a party to a lawsuit have. Has a lot. I'm going to hold on to this for Q&A. I'm going to answer that question. It's a good question. We'll get there. The court says, what is the evidence that supports? And she cuts him off and says, I don't need evidence to support my statements. The law allows me to say what I believe is true. I don't have the burden of proof that what I said is true. The First Amendment says I can say what I believe is true. The court then says, ma'am, we are at the motion for summary judgment stage. They have moved in their papers that there is no genuine dispute as to material fact as to the two defamation claims they are bringing against you. And the plaintiff is arguing that she is entitled to a judgment as a matter of law. And she starts to say, I disagree. And he says, no, you need to let me finish. He says, that is what she has set forth. And if I decide that she has met her initial burden and that no genuine dispute of legal burden or that no genuine dispute of fact exists, then the legal burden shifts to you to identify facts that show a genuine issue at trial to defeat the motion. I can't just accept your word. I need facts that are admissible. You have not yet provided me with any facts. You have provided me with tarot cards and your spiritual intuition, and those are not facts and evidence. You need to identify facts and evidence that show that you can bear your burden. And at this point, I'm like, oh boy. Yeah, this motion is getting granted. This was the part where I was like, this is the part. The court has spelled it out. That, look, ma'am, do whatever you want with your tarot cards. But what you can't do is accuse someone of murder. We're not to the part where she calls the professor a murderer again yet, though. It's coming. It's coming. We're not there yet. The court says, essentially, I need you to identify the facts and evidence that show that you can bear your burden. And she says, you say that those aren't facts, and that proves that the plaintiff hasn't met her burden. This is where her argument is incredibly clever. She says, you saying that tarot cards and spiritual intuition aren't facts proves that the plaintiff has not met her burden and that they are my opinion, and opinion cannot be defamatory. So her throwing back to the court, if it's not a fact, because remember, The standard for defamation is a material statement of fact. So now she is arguing, well, if you're saying, Your Honor, if you're saying that my tarot cards and my intuition aren't facts, then it proves that it's opinion. And if it's opinion, she hasn't met her burden. And at this point, she is playing games with the word fact as it is intended here versus as it is intended in the defamation statute. Because in the defamation statute, a statement of fact means that you have made that statement as factually based. And here it means that it's admissible evidence. So it is two different ways to interpret facts. However, when I say that it is clever, I see chat, some of you are saying, manipulative. Fair. But she is very much being intentionally obtuse and saying to the court, if you're saying that tarot cards can't be facts, how can it be defamatory, Your Honor? Boom. Like I felt her just being like, boom, roasted. Boom. Like I could feel it coming across because she at this point had raised her voice quite a bit in arguing that, well, if you're saying it's not a fact, they haven't met their burden because it's opinion. And she says very clearly, Your Honor, opinions cannot be defamatory. She is, of course, willfully misinterpreting what any of that means. But it is very much a twisting of what is happening here in court. But it, again, this is not a lack of perception, right? This is not her not understanding what's going on in court. She understands full well what's happening in court. And she is trying to game it to her advantage. And she said, in order for the professor to be entitled to this motion, she has to meet the elements of the claim and prove by a preponderance of the evidence. She, plaintiff, has to prove by a preponderance of the evidence, that's what she said, that what I've said is false. And her declaration is hearsay, and she cannot prove that it's false. And the court cut her off and said, no. Her declaration is not hearsay. It's undisputed. And goes on to say, because you have not provided any evidence to rebut what she said in her sworn affidavit. And she said, I disagree. The court, she's like, it's hearsay. The court, no, it's undisputed. I disagree. The law presumes that what I said is true. And a declaration from a person who's accused of murder is not sufficient to prove the things that I'm saying are not true. She wants him to prove like a double negative. So a person accused of murder can't just file an affidavit and say they're not a murderer. I wanted the court to be like, that's not literally how any of this works. They didn't. And then she continues arguing, saying, so what you're saying, all a person accused of murder has to do is submit an affidavit, and it's not a preponderance in my opinion, or in the Supreme Court's opinion. I mean, it might be your opinion, but I disagree with that. It's not my intent. And then the court at this point is trying to jump back in, and she just keeps going. Just full on steamrollers over the court, who now probably feels like they're fighting with a teenager. It was not my intent. She has not proven any of it, and my intent is noble. It's not ill intent, so she hasn't even met the bare minimum of defamation. And you're saying, your court, you're saying my tarot readings are mere opinion. She knows what the standards are here, especially when she's talking about mere opinion. She knows what the standards are here. And the court says, you are misunderstanding what I'm saying. There is no vehicle for them to be admissible evidence. They are hearsay. So what he's trying to say is they are not opinion. They are not admissible evidence. Oh yeah, the talking in circles will not stop. But it is very grounded arguing in circles, I would say. She is arguing appropriately to what's going. No. She is having a conversation about the same subject matter. Appropriately is not the right word. But yes, for those of you that are like, this feels like arguing with Daryl Brooks, yes. Mhm. I mean, she's representing herself. It costs her nothing but an internet connection to show up in Zoom court. It doesn't cost her the hourly rate of the attorney that the professor is paying for. Don't worry, that comes up. She brings up how popular the professor is and that her reputation can't be damaged because she's more known now. It was giving I Made You vibes, like Abby Lee Miller. You're nothing without me. It was giving. Okay. The court says you're misunderstanding what I'm saying. There is no vehicle for them, tarot card readings and spiritual intuition, to be admissible evidence. They are hearsay. And she said, I agree, it's an opinion. That's, again, not what the court said. She's like, yeah, you're right, Your Honor, it's an opinion. I agree that it's an opinion. I only sent a tip to the FBI to investigate her. I never said arrest her on my opinion. And she said, why am I here? I never even said somebody should arrest her. She said, I have the right to tell everybody what I believe is true, and I have a right to do so anywhere I want. This is her arguing her First Amendment right. And the court says, and the plaintiff has the right to sue you for defamation. And she said, no, she doesn't. It's an opinion. Q Tamara judge. It's like my opinion. The court cut her up. And the plaintiff has the right to sue you for defamation. She says, no, she doesn't. It's my opinion. The court says, can we please address? The court is now done. That was all that the court, I believe, has found the undisputed facts that there is no legitimate material fact dispute for trial, that the defendant has the burden shifted to them and has not addressed the burden with admissible evidence, and therefore the motion for summary judgment cannot be, or the motion for summary judgment will be granted. So I think the court has gotten to the end of this and said, okay, fine. Can we please address why this is not outrageous conduct that is the basis for adding punitive damages? So the court now is trying to move her on to the second motion about punitive damages. From the court's question, the plaintiff has the right to sue you, and it's undisputed because you've not presented anything to dispute it. I think the court is asking if she has anything to support her burden because the burden is shifted and the summary judgment will be granted. So, can we please address why this is not outrageous conduct? And she says, when I received the cease and desist, I did not comply with it because I believe the findings of the tarot reading to be true, and I have a First Amendment right to say what I believe is true. I posted it to get attention. And that statement is going to bite her so swiftly. So swiftly. She doesn't even know what she said. She doesn't even know. She doesn't even know what she said. I posted it to get attention. Exactly. You wanted that statement to be distributed far and wide. And that is why you're being sued for defamation. She went on. I posted it to get attention, to get her investigated. I wanted everyone to see it, but I'm paraphrasing there because there was more and I couldn't type fast enough. And then she goes on to say, had she been investigated for murder, or had she been investigated, I would have apologized and stopped investigating myself. The court said, but did you get the Moscow police response that she was not involved, which was attached to everything. She said, no, they never said they investigated her. They said they believed that she wasn't involved. And that says to me they didn't investigate and she wasn't cleared. I took it as they don't believe me. And no one has shown me that she has been investigated. And then she goes on to say, I got a cease and desist from a murderer to stop telling people that she is a murderer. I don't have to listen to that. Chat. Chat. What? What is happening in federal court today? I was typing this and my jaw was on the floor. I'm sorry. What now? Ma'am. That is a direct quote from this hearing. I'm sorry, guys. I can't go code any redder. I got a cease and desist from a murderer to stop telling people she is a murderer. I don't have to listen to that. And my notes at this point just say, wow. And I don't have to stop. I believe these are events leading to the murder. It wasn't malice as required by the Idaho statute. She's misinterpreting the statute. Maybe she isn't happy because I'm accusing her. Oh, you're accusing her now. So it's not opinion, is it? It's an accusation. If it's an opinion, it's not an accusation. People could have the opinion that someone is an asshole playing word games in court, but that's an opinion. Saying I am accusing her is not an opinion. Can we get a goat scream? Yeah, we can. Can we go to, I can't go any code redder than this. We're like code plaid. We've gone plaid, people. We've gone plaid. So she has admitted that the TikToks are hers, that she published it on social media so that it would gain attention. Her hope was for an investigation, but she published it on social media to be disseminated and seen. That she believes the professor is a murderer, that belief is not founded in anything beyond her own clairvoyance, tarot card reading, spiritual intuition, or because she's the flesh of God or whatever. That she's accusing the professor of being a murderer, which sounds like a statement of, I don't know, fact. And that the professor just doesn't like it because she doesn't want to be caught. Again, insinuating that it's a statement of fact. She said, I'm trying to get justice, TikToker, so that's not outrageous conduct. It was done to help. So I continued to post content and ignored the cease and desists. Well, there's that. She goes on to say what the motions or what the plaintiff's motion for leave to amend is more aligned with is the false narrative that I made up a false story for pecuniary gain, but that narrative is false. The truth is that I tried to get justice. Justice is not adding punitive damages because I tried very hard to get justice. Whether it's true, the accusations, doesn't matter because there is no ill intent. This is not defamation of a public figure, and I don't think this is how this works. And I am deeply I am deeply invested in this at this point because we have gotten to a time where the things people think they can do on social media are fucking wild. I love being a streamer. I hate few things in life, but I hate the trend of the like IRL prank, but not prank, like public harassment streamers. And I think that free speech needs to protect lots and lots and lots and lots. But there are boundaries, and accusing people of committing crimes on social media for attention is outside of the boundaries of the First Amendment and of civilized society. And I think punitive damages, as we've gone through this again, I think punitive damages should be added, but I don't know if there will. I also think we need stronger public harassment laws before people get seriously hurt with the prank and IRL streaming. The people who are going to other countries to do it are going to get thrown in prison. But it needs to also happen here. It is not protected behavior. Christine D in the chat says she is the Simone Biles of mental gymnastics. I think that is accurate. I also hate the prank streamers. I hate it. I hate it. I hate it. I hate it. And I think it's dangerous. If I didn't think it was dangerous, I would be like, oh, that's annoying. I think it's dangerous. And that is the bigger problem. I think it is incredibly dangerous. So she says justice is not adding punitive damages because I tried very hard to get justice. Whether it's true or not doesn't matter because there's no ill intent. I think this is an acknowledgement that she knows that what she's saying is not true. And this is as close as she's going to get to admit it. The rebuttal from the plaintiff was, quote, she cited case law and then said, the truth of the statements is a defense that must be proven. And then she goes on to address why the mental state that the defendant keeps referring to is the public figure standard and that malice doesn't apply here at all. But truth is a defense. You have to survive through this motion with evidence to get to proving truth as a defense. But she kept saying, it's true, so fuck you, you can't sue me. That's not how it works. And she says you can't make someone a public figure by dragging them into a controversy. The professor is not a public figure. And with respect to the statements on December 12th, 2022, the TikToker said, plaintiff is going to prison whether you like it or not. And then she addressed that these are all false statements of fact. They are bad acts and they are not opinion. And that the indictment of Koberger gives no indication that there was anyone else involved. All of it makes clear to the defendant that there is no fact or substance to her statements. And they asked the court for leave to amend to add the punitive damages and to grant the motion for summary judgment. And the court starts to talk and she said, I need to respond, or may I respond? And then the TikToker says she mentioned a video where I said that the professor's going to prison, whether you like it or not. And she goes, Your Honor, that was a prediction. That was the result of a prediction that in the future, she will be arrested and she will go to prison. And she, professor, hasn't provided any evidence of damages to her reputation. And those are false statements. Her reputation has actually increased. And you can see it by her GoFundMe. And the court cut her off and said, that's not for my consideration. We are not talking about damages. We are talking about these motions. And then the court started to wrap up and said, thank you. Your arguments were very helpful. I appreciate everybody being ready to argue today. I will try to get an order out in the near future. I appreciate all your participation today. Is there anything else? Everyone said no. And then the hearing wrapped up. The audacity. But it shows how difficult it is to navigate the court process linearly with someone who is not going to navigate the court process that way and will obfuscate at, and I can't pronounce that word, but it is the right word. At every opportunity. She will try to deflect, to change the narrative. And I think the way that the court is going to have to handle this is by granting the punitive damages. The court has been very patient. And I said this when we were frustrated at the beginning. At the beginning, I said, I'm annoyed that the court is being so patient. I'm annoyed that the court is doing this and that. But I said the court is being patient on these rulings and making a very thorough record so that when the hammer drops, there is a very thorough record that the court has given this defendant every single opportunity. And I think we have reached the find out part of fuck around. I think the court will grant the motion for summary judgment. If the court grants the motion for summary judgment, it means that the TikToker will be found factually liable for defamation. So she will be found, it's not guilty in civil court. She will be found liable, just guilty in civil court, of defamation. And then if this goes to trial, it will go to trial on monetary damages, and they will argue punitive damages. The professor will argue the amount of damage this has caused to her reputation, to her personally, to her family, and that essentially we can't allow this type of behavior. Punitive damages are allowed to send a message. We cannot allow this type of behavior. And the court and the jury, if it goes to a jury on damages, needs to send a message that this is the boundary, that you cannot do this. You cannot accuse someone of crimes and say, but I believe it, so it's fine. When you have no basis in fact. This is not name calling. This is accusing someone of horrific crimes. And the plaintiff said at the beginning of this case that this defendant leveraged the tragedy in Idaho to further double down on what happened to gain attention and notoriety or infamy for herself, for monetary gain on TikTok, for attention, for clicks, and for views. So I think we've reached the find out. The second that we do, I will cover it. You want to be in the app because if this ruling comes down while I'm covering the Karen Reed trial, I will update you in the app first and do a quick bit on it. But this is someone who is not going to change their behavior without pretty strong sanctions by the court, and maybe not even then, which means the professor is going to have to pay for 18 months of a lawsuit and then is going to have to pay to try to recover. Recover what, though? They want this TikToker to stop, but this TikToker seems to feel that they have nothing to lose. And so why would they stop? And it's wild. So I think we're going to see the court smack this down. We need quickly to talk about Kevin Franke suing. How am I doing on time? I'm doing okay on time. We need to talk quickly about Kevin Franke suing. I don't know how much time I will have for Q&A. I'm going to do my best. Actually, there were a couple questions really on point to this case. Let me try to grab those real quick. Motion for code purple when we need red again. Maybe. I have to figure that out. Grace says we have a special business court in Delaware. Why don't we have a special Shadow Realm court in Florida? This is in Idaho, but maybe. I mean, if she wants to astrally project herself to court in another dimension or universe, then she should do that. I don't think it's going to help, but she could. Just BKZ says we can't cross-examine the tarot cards. It's hearsay. Yep. Flower Joe said hello from Australia via Australia. First live ever. Glad to have you here for your first live ever. Malice says, I feel like we are so close to a legit and awesome card game here. The Great Big Geek said, Judge, those are not in fact facts. Those are indeed fuckery. We have reached peak fuckery in this case. Loving that shirt and lippy, Slay Queen. Thank you. We've got a full mood today. Code the more you know. Rainbow. Cyborg asks, can she get a sua sponte mental exam possible? No. The court really can't just order an exam because there's no ground for it. Miguelina, that's fine. Thank you. Princess Claudia said, but she is stating her opinion as fact. That is the point that she keeps missing. But do you see the parsing and spinning of words? Anyone who's ever argued with someone who does this, again, I am not a psychologist or a psychiatrist, but we know people who do this, right? Anyone who's ever had to argue with someone who will just keep spinning and spinning and spinning and it is impossible to get to the end, has a lot. So, Emily, why is this civil suit being seen by a federal judge? Is that normal? I thought they only saw criminal cases. In the US, lots of civil cases play out in federal court. There has to be a reason that the court has jurisdiction over it, and that can be diversity of the plaintiffs, as exists here. So resolving a lawsuit between plaintiffs in different states, that can be appropriate for federal court. Federal court also has pretty strict procedures and a lot less fuck around, which might be why they brought it in federal court, not state court. It's also much easier in federal court to subpoena and bring in people from other states because the subpoena power of the court is national instead of regional. So it's very hard for a court in Idaho to go grab somebody that lives in Texas and be like, you need to come to court here. A federal court is like, yo, we're the US, you're in the US, I'm in the US, go to court. So there's a lot of reasons to choose it. But yes, federal judges cover both civil and criminal proceedings. Most of the federal cases we have covered, or I have covered on this channel, most of them, not all, but most of them have been civil. A few have been criminal. So good question. Maury gifted 5 memberships. Thank you. Dominique, I wonder if she watches your coverage of this. Oh God, please no. I don't need to be dragged into any of this. Let her be mad at Atuzzi and Marquis and Inabber. Katrina says she is the definition of willful ignorance. Yes. Code brown, a combo of red and green for BS. I don't know if I'll look cute with a brown background though. That's part of it. I'm so going to rant about this case to my bestie tomorrow. Oh my God, it's wild. Roy says, I need a y'all. This case is not a one y'all. This is like a y'all. That's what that is. All right. Question, do we know how TikToker got the professor's name? T. Montanus. I think I got that right. Yes. She went through the University of Idaho website and got to the history department and did a, she says, psychic reading on the entirety of the history department and got a hit on this professor. Barbara said, I'm excited because I was called for jury duty. Have fun. A friend of mine got called for jury duty to one of my other friends' courtrooms, and the case resolved before they ever got to go in. And I was like, damn it. That would have been fun. Can this poor professor sue for attorney's fees? She can get punitive damages, but where are you going to get them from? Probably wouldn't get them, but dang, they've got to be piling up. Yep, that's why there's a GoFundMe. Pamela said, why short of damages? This was earlier. The summary judgment can only be granted on material issues of fact. Damages are for the jury to decide. So if this is granted, there's no defamation case. There's only a trial on damages. It's like when you go to trial just for sentencing, whether it's a death penalty case, whether it's life or LWOP or death, the liability issue will be determined by this motion, possibly. And then it will go to court on damages. I saw in the chat, at what point does this flip to criminal? It doesn't unless there's something criminal that happens or unless the court issues an injunction to stop the TikToker from saying these things. Like, I enjoin you from referring to Professor Schofield as a murderer, as commissioning a murderer, as having an affair. If the judge issues a court order with all of those things and an injunction on all of those things, which might be the only thing that works, and she violates that court order, then there's possibility that we get into the realm of what sanction may be appropriate there. But if I don't get to Kevin Franke, we are not going to get to Kevin Franke. So let me get there real quick. This is coming helpfully from KUTV. Kevin Franke is suing Jodi Hildebrandt. This comes after Jodi Hildebrandt has pled guilty and been sentenced to some period of time, up to 30 years in the state prison in Utah. This is a new lawsuit. I'm going to I might put it on the docket depending on what you guys think, but it's going to take a minute before we get back round to it. If we do put it on the docket, I wanted to go over it briefly because everybody's talking about it and I got a lot of DMs asking about it. Again, because we are going to be talking about the Franke case, the basis for this case is what happened to the children. I am not going to get into every single allegation there. I'm going to go over this very broadly. If you're interested, KUTV posted this, and I can post the story if you want to read it for yourself, but I'm not going to read out everything. Lyndon said, EDB, you called it. Thank you, Lyndon. You wondered if Kevin was going to sue Jodi. I did. There are certain things you can kind of see coming, especially when she listed her house for $5 million. He filed a stay that if the house gets sold, that it should go to criminal restitution, which is probably the easier way to get this. But he's now suing her individually, and we will see if he's suing on behalf of just himself or others and why. Kevin Franke, through his attorney, is suing the defendant for the following. Lou said, I don't get why he's suing. Lou, I'm going to hope to answer that question. That's why we're covering it. Plaintiff is a resident of Utah. Defendant is a resident of Utah. Defendant currently resides at the Utah State Prison. I imagine he was happy to write that. Defendant's tortious conduct occurred in Washington County, Utah. The court has jurisdiction over the parties. The plaintiff is the father of 4 minor children. While plaintiff was residing in Utah, beginning on or about May 22nd, 2023, defendant, in collaboration with plaintiff's then wife, Ruby Franke, they're estranged. The divorce isn't final yet, but still. Mother of the 4 children moved the 4 minor children into defendant's home in Ivins, Utah. Neither defendant nor Ruby advised plaintiff of their removal of the children from the family home in Springville to defendant's home in Ivins. From the period of May 22nd through August 30th, while at the defendant's home, defendant did intentionally, recklessly, or negligently detain the children, confine the children. Further, the children were strictly prohibited from leaving the premises under threat of further increased punishment, described herefore. We're not going to do that, or going to jail. They inflicted and allowed another adult to inflict serious injuries upon the children. 2 of the children in her residence committed physical torture against the victim. They described that. The victim was denied water, was required to remain in the heat, and then they go through all of the things we saw in the criminal case. Victim RF attempted to run away. He was caught by Ruby. He was taken home. That's when he was bound. They described that. They described the further harm that came to him in details. That harm that they caused to him caused injuries. The injuries were treated with, I'm going to say, quote, homeopathic remedies, cayenne and honey. That is not sufficient for the harm that was caused. That is my statement. That's not in the lawsuit. The actions caused severe emotional harm to minor child RF. They began in May and escalated through the summer. Defendant and another adult regularly sought to indoctrinate RF and convince him that he was evil and possessed. He needed to be willingly obedient to avoid punishment. The punishments were necessary to force him to repent. The indoctrination, like the psychological damage here in combination with the physical damage, is going to be very difficult for these children. He was told that the abuse that he was suffering were acts of love. Abuse is not love. Abuse is not love. Abuse is not love. Both children were present in the home and saw these actions being taken against each other by defendant and Ruby. Defendant caused severe emotional harm to the children. And then they go into other isolation and psychological and physical harm. They talk about the other victim who was repeatedly told that the harm towards her was acts of love. The abuse was acts of love, that it was being done because she was evil and possessed, that the things were being done because the victim child needed to repent. It talks more about the physical harm, then it talks about RF's escape, RF asking law enforcement be called so that he could be taken to jail. This latter request was because he had been so indoctrinated by defendant that if he escaped, he would go to jail. And you can see that in the jail calls that the victim acquiesced, like, can you just take me to jail? Instead of jail, he was cared for by first responders and taken to the hospital for severe malnourishment and for treatment of his wounds and injuries. It talks about the arrests, the first responders, how difficult it was for first responders to build trust with the other victim that was found in the home. That is now all public record, and you can see that for yourself if you choose, caution advised, to engage with the videos showing how terrified victim EF was when law enforcement tried to have her come out. They weren't going to just like grab her, of course, and take her out of the home. So you can see some of the psychological harm play out there. It talks about the fact that the children's personalities, emotions, and psyches were damaged and altered beyond Kevin Franke's ability or capacity to restore them without professional intervention. They absolutely need professional intervention that has nothing to do with Kevin Franke. And they say that the state's resources through the juvenile court are helping that. But through rehabilitation and the restorative process, is how he describes it, directed and prescribed by professionals in order to restore his children to his care in their home, he has complied with the court processes and has sought his own professional help, therapy, not only in order to coordinate with the children's treatment, but to gain an understanding of his children's conditions and needs and how to support them, essentially. It says that the intentional or negligent acts of Jodi have completely damaged and altered, it says for the worse, Kevin's marriage, the children's psyches, personalities, behaviors, and that it has dismantled and exploded his family and his personal life. We have seen this echoed by others that have interacted with Jodi Hildebrandt, been victims of Jodi Hildebrandt. They say the consequences of defendant's intentional and negligent acts were foreseeable as to the effect on these children. The fact that the defendant, Jodi Hildebrandt, has some level of psychological education and training and worked as a professional, I believe psychologist, not psychiatrist, is going to go a long way here to show that she would have known, or it was foreseeable, that this would have a negative effect. So Kevin is suing for intentional infliction of emotional distress, that the defendant acted with reckless disregard of causing emotional distress to Kevin and Kevin's children, that Kevin himself suffered severe and extreme emotional distress because of Jodi's conduct, that the cause of his distress is Jodi's conduct. He's also suing for, and I don't doubt that there is damage to Kevin there in all of this. Negligent infliction of emotional distress, which is a different version of the same cause of action. That defendant's conduct unilaterally caused Kevin to sustain severe emotional distress, which has been characterized by illness or bodily harm. This is kind of boilerplate. I don't doubt that he has had to seek quite a lot of help due to what has happened. It says, as approximate result of Jodi Hildebrandt's acts, Kevin has suffered past and future non-economic damages, pain and suffering, emotional distress, loss of quality of life, and loss of enjoyment of life. He is arguing also that this exploded his marriage. So he's lost his marriage. His kids are forever altered by the things that have happened. I hope that they will heal. Kids are incredibly resilient, but the amount of trauma here, no matter the resilience, is going to have lasting and lifelong effects. And then negligence, that the behavior was negligent, that defendant undertook duties and responsibilities with regard to Kevin and the minor children, and that conduct was negligent. I'm surprised they don't mention her training. Let me see. I might have missed it as I was zooming. Hold on. Did I miss it when they described Hildebrandt? I might have. Let's see. No, they didn't. Defendant's a resident of Utah, currently resides in prison. It's interesting to me they didn't list her training. Maybe they don't know it to verify it, but she talked about it quite a lot. She talked about it in that police interview, remember? She's like, I'm normally on that side of the table. Well, you're not on that side of the table today, Jodi. Not today, Jodi. Sorry, the rage I have for these two women is why I didn't cover this case a ton. It's not helpful for me to just rage at you. That's not legal commentary. That's just mirroring your feelings. It's not really helpful. Let's see. Defendant, as detailed in the statement of facts, breached her duty of care and reasonable behavior of conduct. I wonder if they will get through her education a bit somewhere. Defendant's breaches of duty and negligence caused Kevin economic and non-economic damages. Prayer for relief is past, present, future special damages. This is a way that they are trying to make sure that whatever money Jodi Hildebrandt earns from selling her house goes to healing these children. I hope that some of it, if this civil suit goes forward, is put in a trust. So we'll get there. For all past, present, and future losses and harm, for punitive and exemplary damages might be determined at trial. I think this is going over this a little bit. I think this is to try to make sure that any money that does not go to the children in criminal restitution also is received by Kevin, that Jodi is not benefiting from the selling of her house. I think most of the money should go to the children through criminal restitution. I think this is to kind of sweep in the rest of any money they can get from Jodi, including the 60 whatever $1,000 that was in like a bag at Jodi's house that Ruby had cleared out all their bank accounts. It looked like Ruby had not only cleared out their bank accounts, but cleared out like any money the children made on YouTube as well. So I think there's room for Kevin through his lawyers to try to make sure that this money doesn't go to Jodi. And the court can apportion it. Is it $85,000? I could very well have the numbers wrong on that. I don't 65 blah blah, somewhere upwards of 50,000 and less than 100,000, tens of thousands of dollars. Because I didn't pull up my notes on that, but there is money. Sandy says the kids need the money, not him. These are grown adults. This lawsuit is ridiculous. Sandy, with respect, he is going to have to care for his children at some point in the aftermath of what she has done. And if he is going to have to pay for the therapies, the treatment, the ongoing care for them, some of that should come from Jodi, if it doesn't all come from criminal court. The chat is like, no, it was 85,000. Thank you, chat. The cash in the gym bag. So if he gets custody of his children, then this money should go to their ongoing care. And the court can structure that, and the lawyers can structure that into a trust so it is for the children's ongoing care. So I am not cynical about this just yet. I might get there. I might get there. But I am trying to go into this optimistically that this will go to the care of the kids. The court can structure that. But this depends on what the criminal restitution does. And at some point, you have to bring these lawsuits to start the process. So the children are going to need restitution and support and psychological support. And again, Emily, you said you weren't going to rant about the lack of adequate mental health care in the United States medical system. Mental health care, especially the variety of providers these children might need throughout their life, is not inexpensive, is not always easily accessible. It is a tragedy, and it is a failing, and it is a failing for quite a lot of people. But if he can take that money from Jodi Hildebrandt's sale of her house and whatever other money she has and get it back to his kids, then good. If he gets this money to take for himself, then I have problems. If he gets custody of his children, and that's a more complex situation. If he gets custody, he does not, I think, have custody of his children yet. The family law case is not done yet. I think there is still ongoing questions about that. But could he down the road add the caregivers of the children to this? We'll see. I don't know if he would, but he is suing for the psychological damage caused to himself because of what was done to his children and because of what was done to him. So we will see what happens here. But he's not suing for the children. That is in criminal court. He is suing on behalf of him, but arguing that some of why he needs the money is that it will go to the children. With that, I'm going to get to a very, very, very brief Q&A because I do have some appointments, unfortunately, today as well. I have to go to the eye doctor. I turned 45. I cannot see the right way any longer. So it is a whole bunch, it is just a whole bunch of things. I'm going to get to a few quick questions and then we are going to go. I wanted to bring up this lawsuit. I am trying not to be completely pessimistic going in. I understand if you are. But I'm trying to see what happens here. And I'm not mad if people take all of Jodi Hildebrandt's money. I'm not. We'll see how it happens. Did you already cover Karen Read? Tomorrow's podcast is Karen Read. And then when we have a jury, we will start. I feel like that's going to take a minute. Did you make your appointment yesterday? Kind of. We modified a little bit, so we made it work. They're very patient with me. People know what I do and are very, very patient with me. They also know that I'm ADHD. We were also wrapped with streaming. We just forgot. Terry, I saw this earlier in the chat and I am still emotionally wobbly from a close friend of mine recently losing a parent and from yesterday's court coverage. But I wanted to pull it up and say that I am so sorry for the loss of your mother. It is losing. Look, grief is really hard. Loss is really hard. Yesterday's hearing was really hard. Grief is just such a difficult thing to navigate and it stays with us. I hope that the good memories stay with you as you navigate the grief. It is also a tremendous amount of things to do. Just let yourself do the things you need to do, feel the things you need to feel. And I would say find yourself a mindless game on your phone for when you need to just have a minute. And I am always happy to drone on and on about ridiculous law shit in the background while you play match games. Terry, the law nerds are thinking of you. I am sorry for your loss. It's a very difficult thing. Ann Bell said, motion for Orange Cat, motion for Code Fred. Today it would have been a Code George, but I couldn't. The fuckery was too strong in Idaho to pull a Code George. George just wanted to be here. George is like, you're agitated. So we just wanted to be here. Kim said, I wonder if the TikTok psychic pulled the justice card. Pull that woman some towers. Jason said, EDB, can we do a members only with the Ethan Klein versus Weinstein Kavanaugh case? It's been a minute. Jason, I'll take it under advisement. We do have a bunch of catch up we need to do on cases. There's just so much new stuff and it's hard. Learn Knitting Now said, is the TikToker judgment proof? Maybe an injunction. But I don't know how much is there, right? I feel like the TikToker's toad swinging from the chandelier, burning it down. What are you going to do? And she said that in videos. What are you going to do? And that's hard. Thank you for the gifted memberships, Kate. Will K suing first affect the amount available to the kids? The criminal restitution should come first. That was filed first. This should go in line after that. And this will resolve after that. Criminal restitution will be done sooner. Chad did a Q&A stream on Twitch that explains a lot. Thank you for that. Jasmine said, first day off from tax season. This house elf is free. Jess said, I'm behind, but a SoCal-based hockey team, CV Firebirds, plays Take Me Home Country Road every game. We also like hockey in the desert, though. So, yeah, Arizona really loves it. Member for 38 months. Wow, how time flies. Yes, it does. We need this done with multiple voices. EDB, use the buttons. I was so frustrated I couldn't. Jenny said 5-day post-ops. Thanks for keeping me company. Ems and Lawnards. Oh, we're going to be in trial. So if you guys don't have the app yet, we're going to be in trial. Can't think of a better way to rest and heal. Do that. Grateful. So grateful for all of you. Proud to be a Lawnard. Even got my dad and Nanny to watch with me. Jenny, heal well. Oh, you're right, Miguelina. Miguelina reminded me of something I need to mention. Question, is there any way the court establishes that the TikTok psychic is mentally stable? Through the Q&A. I mean, just because we aren't operating the same way the TikTok psychic is operating, the TikTok psychic is very clear and aware of what's happening and aware of what she can and cannot do in court and is making conscientious choices that are really adverse to her, interest in court, but is making choices. She knows what's happening. So Brandy says, I believe Jensen Ackles is my soulmate. Does that make it true to the TikToker? Thank you for all you do, EDB. Looking forward to watching the Reed trial with you and the Lawnards. It's going to be wild. Stephen, good to see you. Just popping in to show the love. I'll be writing with the replay crew. Don't forget to do the YouTube things and share. We got to get M to 1 million. Thank you, Fiona. Thank you for the gift of memberships. Casey Cat said motion to code black. I don't know why we would do that. Katrina said Young is rolling around in his grave. Ma'am, tarot cards are supposed to be a self-help tool based in proven psychology to make you a better human. Well, she's using them to accuse people of murder and then quadrupling down on it. Griselle Holderness, thank you so much for the gifted memberships. Roy, thank you for the gifted memberships. Cooley Coolin said, hello, good evening from Sweden. Bridget said, what a lovely community. Thanks for enriching my life. You're welcome. This community is the bomb. Elise asked if I will cover the Michael Kulesi trial. I don't know. It is really, timing is a huge factor for me between now and August. When I have looked at my calendar between now and August, I kind of go, what? Like, what? I can't. It's like my son, when he sees like an electric, like Mustang or somebody who has like slammed their car really low and then like pulled the wheels out to the side. I'm driving along and he's just like, what? And I'm like, what is happening? You sound like Vicky Gunvalson in the back of a van on a Real Housewives trip. And he's like, that car. I'm like, oh my God, so dramatic. And now I do it. So dramatic. So Lou said, can he win the lawsuit if he doesn't get custody or it's not affected? He's suing on behalf of himself. So it will be argued, but I don't know if it will exclude him because he's suing for his own damage. All right. We need to talk about one more thing because I'm excited to share it with you. Real quick, we're going to do just a real brief, hey, go show this thing some love. We're going to put a link in the description down below. But we got to talk briefly about Rust real quick. There was a very interesting article from People. Maximum sentence for Rust armorer should be a wake-up call for Alec Baldwin ahead of trial. Expert exclusive. Can you guys guess who the exclusive expert is? I really like Eric Anderson over at People. Alec Baldwin heads to trial in July for involuntary manslaughter in connection with the accidental shooting death of cinematographer Helena Hutchins. Rust armorer Hannah Gutierrez Reed, who in March was found guilty of involuntary manslaughter in connection with the fatal 2021 shooting of cinematographer Helena Hutchins, was sentenced to the maximum penalty of 18 months in prison April 15th, according to legal expert Emily D. Baker. Hello. I am Emily D. Baker, a lawyer and former LA Deputy District Attorney. The sentence handed down by the New Mexico judge Mary Marlowe Summer should be a wake-up call for Alec Baldwin, 66, who heads to trial for involuntary manslaughter in July. Quote, The court is taking these cases very seriously. Yep. Gutierrez Reed, 26, oversaw the prop guns on the Western movie. Star and co-producer Baldwin was holding the weapon when it discharged. He fired it. I understand people's lawyers are going to be like, what we're not saying is he fired it. Like, I get it. Director Joel Souza was also shot in the shoulder but survived and returned to complete the filming of Rust with Baldwin in 2023. Baldwin, who has insisted he did not pull the trigger, also faces up to 18 months in prison. Regarding the Gutierrez Reed sentencing, Baker, who is not involved with the case, states, I imagine Baldwin and his legal team are going to be having serious discussions about what it means if he is convicted. I stand by that. So I'm not going to read the rest of the article. If you guys want to, I think Eric does a great job. I have always very much appreciated the editorial standards of people. I know that they have lawyers that vet all of their articles. I appreciate how fact-driven they are, and how much they focus on making sure, especially when I've worked with people, I really like Eric Anderson and others at People, including Dave Quinn, but how much they focus on not just pulling quotes that I've said when I talk to them, but making sure that the overall point is not missed and quotes are not just spliced in. I appreciate the integrity with all of how they report, which is why I am sharing it with you. So make sure that you go hit the link and show the article some love. So Miguelina, thank you for reminding me. I almost forgot. Sometimes we've got to celebrate. We've got to celebrate the moments. Pop culture legal commentary is my favorite. And I don't know if we get more pop culture legal commentary than Exclusives with People. I mean, other than what we do here, of course, every single day to tens of thousands of people. Not just people. Law nerds. Tens of thousands of law nerds. And the law nerds are the best nerds. Law nerds, I hate to leave you. I have to be able to see. So I have to go so I can see. The link is in the description. So I am going to run so I can make my eye appointment and everything else I need to have happen today. For the few of you that I saw, the members that asked about whether or not we were doing a recording for the podcast today, I had to record over the weekend and I recorded very late. And I chose to not record it as a live stream because so many are like, wait, I missed it. It was so late. It's a very busy week. We will have another behind the scenes recording. I will give you more heads up. It will probably be this weekend as well, depending on what happens with jury selection in the Karen Reed case. And if I go to Georgia on Friday, there is appellate court oral argument in the Chrisley case. If we are starting the Reed case, I do not have time to, go down to Georgia and sing The Devil Goes Down to Georgia as we cross between Tennessee and Georgia multiple times before we get to Georgia. But if the Reed case is still in jury selection, Friday might be a field trip day to Georgia to see what happens in federal court. So if you don't have the app, now is the time, because the entire streaming schedule is going to be fluid based on that jury selection and trial coverage. Law nerds, you are the best. If I did not get to your question, I apologize. We will get to them. I appreciate you, and I will see you in the next one. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.